we're good.
Okay, so thank you. So today's discussion is on mindfulness and the law. Sorry, the sun is still tripping me off. Okay, so today's discussion is mindfulness and the law, what to worry about, what not to worry about, and how to tell the difference. And then we'll have a Q&A at the end as well. So we have two great presenters today. I'm very excited. And I shall introduce them next. So Chrissy Watson is a practicing intellectual property attorney in Silicon Valley with 20 years of litigation and transactional experience in the public and private sectors. Raised in the Thai Theravadan tradition, she's pleased to be bridging her lifelong vipassana-based mindfulness practice with her experience in the corporate world to provide mindfulness and insight meditation training to entrepreneurs and professionals. Using her Mai Pen Rai Mindset method, she teaches her clients conscious leadership and how to show up in the world with ease and integrity. And that sounds so awesome. I can't wait to hear all of that. And then we also have Rebekka Bonner, who was introduced to mindfulness meditation while working as an assistant general counsel at Goldman Sachs in Wall Street in 2005. She's interested in bringing mindfulness to the corporate setting, particularly to legal and finance professionals working in several contexts. She has practiced at Skadden Arps, has served as general counsel to several asset management firms and hedge funds, has represented asylum-seeking survivors of genocidal rape pro bono, and has performed public service in the House, the Senate, the White House, and the Pentagon. Bonner earned her MBA from Harvard Business School, her JD from Yale Law School, and is currently based in Manhattan, New York. In her spare time, she practices mindful wildlife travel photography. That sounds awesome as well. So I will now go on mute and I will let you take it away. Thank you very much.
Okay, I'm getting a box that I've been unmuted. Can everybody hear me okay? Fantastic. Okay, now my personal intention for today is to get better at screen sharing. So you're about to see how successful my practice has been. I'm about to try and screen share a PowerPoint with you. And you should be seeing that now. Isabel, is it working? Fantastic. Okay, so away we go. So very, very pleased today to be teaming up with Chrissy on the West Coast. I'm here on the East Coast. And between the two of us, our intention is to leave you with a better understanding of the issues you'll face from both a process and from a content perspective when teaching mindfulness to professionals, particularly professionals in the legal field. And this first slide will give you a taste of how we'll be splitting this session into two parts, both mindfulness in the law, which will be my first part of the session, where I'll be focusing on content presentation and market segmentation issues as you pick your spot and aim for a particular student body within the law and the legal profession. And then I'll turn it over to Chrissy about 25 minutes in when I turn into a pumpkin and have to leave the call. And Chrissy's going to talk about process issues, so relevant legal issues you'll face in your mindfulness business as you go about teaching in a legal manner. So that's the agenda for today, and we hope you enjoy it. So I'm going to try and advance the slide. I think it worked, yes. Okay, so again, part one, mindfulness in the law. That's what we're going to focus on now, and then Chrissy will be doing mindfulness and the law, ethical and legal issues. And after each of our 10 to 15 minute chunks, there'll be time for Q&A. Okay, and both of us are available via the platform after the call, so feel free to reach out if there's something that we weren't able to cover today, but something may have sparked a question either during or after the call that went unanswered, so no worries there. Okay, so for my part, the basics, what, why, and how to teach mindfulness in the law. We're really lucky when teaching mindfulness within the legal profession because in this profession, mindfulness enjoys a well-established legitimacy. Just as to the use of mindfulness with trauma populations, particularly with pro bono lawyers working with survivors of various traumas, to the fact that it's in vogue right now across the very topmost law firms, particularly those servicing finance professionals, where this is a very hot thing to do in your spare time, to law schools. We're riding a wave of popularity and legitimacy that sort of short circuits the need to explain yourself and explain mindfulness in the profession. We also are lucky in that mindfulness teaching and the profession of the law shares a natural body of values, right? The values of balance, equanimity, objectivity, neutrality, empowerment, and deep inquiry, basically everything that is represented by the universal symbol of law and justice that you see on the right there. That's Themis, the Titan goddess of justice and law, later Romanized as Justitia, and something you can see in most courtrooms or on top of most legislative buildings. So this is deeply embedded in the values of the profession, and so to the extent that you can use these values as common touchstones, it helps you gain standing in a profession, whether or not you happen to be a lawyer yourself. Mindfulness within the law has a neutral definition that comes from a law review article written by a guy named Riskin. I'll give you that reference later. He defined it as a systematic process of investigation that can affect perceptions and behavior. And this was neutralized and secularized by Riskin very purposefully and intentionally to make it something easily digestible by lawyers and legal professionals for whom that definition resonates very naturally. The content, and this is something to not worry about, is really the same material we're learning in the course, simply repackaged for a particular audience. So while your style may benefit from some tweaking and a bit of an understanding of how lawyers think about mindfulness and its value to themselves and their profession, don't feel like you have to be a lawyer to teach lawyers. I mean, Jonathan Faust teaches lawyers all the time. And frankly, it comes down more to, as Tara Brock would say, an attunement to your audiences and your students' needs, rather than being another lawyer. So don't let that trip you up if you're looking to teach lawyers. And the purpose of it really is the same. How do we reduce suffering broadly and efficiently? And that's part of the beauty of teaching lawyers is if you teach lawyers, your impact is naturally expounded because they're part of a network and they themselves are sitting in very high pressure and high impact situations. So if you can reach a lawyer, chances are you're reaching 5 other people just by virtue of the fact that you taught a professional who touches so many other people. It's a people profession, it's not cogs and widgets. So what I would also simply say is this is true of all professions, not just the law, right? The classic 3 professions being divinity, medicine, and the law. And when people say profession these days, they tend to dilute the meaning of that word to say, well, anyone who does something full-time for money. What the profession really means and what lawyers really mean when they say they're practicing a profession is they're working on something that has required many, many years of specialized training, something that requires them at the end of that training to adhere to an ethical code of conduct or creed or formal vow to uphold certain values in the profession. The compensation is completely delinked from outcome, right? You have to pay your lawyer whether or not you're going to jail, or you have to pay your doctor whether or not the surgery cures you. Because what it really is a disinterested and objective counsel or advisor who owes a fiduciary duty to their client. And so you can see just by the language how this meshes so naturally with mindfulness and a desire on the part of mindfulness teachers to have a major impact on the quality of professional services, human beings, in high impact settings. So next slide. Okay, so picking your target audience within the law, right? You see the little grid on the left. I'm going to blow through this slide in just a single minute or two. Many different settings to reach many different, budding or current professionals or their customers. Where you see the column with a little exclamation point, it means, high impact in those places. The column on the right, still high impact. These are the places where you also have a chance of getting paid or having people willing to pay for a class that you might be willing to teach. So, you have to really ask yourself, when I'm teaching mindfulness in the law, what are my goals, right? And you can do a lot of good in a lot of different places. And if payment is not important to you, it opens the aperture. If being paid for classes that you teach is important to you, the right-hand column is the natural sandbox for you to play in. And concerns and special factors for all of these groups: high levels of stress throughout this little grid, depression, lack of fulfillment and balance, and attrition within the profession. It's not just Isabel who fled the law. A lot of people are. And law schools are seeing a downturn in enrollment because of high stress. And yet a place where you can do an awful lot of good, whether you're teaching mindfulness or whether you're practicing law. There are a lot of harmful consequences to adversarial, egocentric, limiting mindsets to the outcome of your legal practice. So you can see how learning mindfulness is something that will increase your skill as a professional, but it also is important to the entire profession to have the process and the experience work well and produce good justice outcomes, good values for folks paying high billable hour rates to lawyers. Pragmatic factors are that again, a little bit of benefit can go an awful long way when you're teaching any profession, and the law is no exception. Next slide. So how to be effective as a lawyer, right? We'll start on the left. There are some legitimacy issues that you want to keep an eye on. And here are the 3 questions to ask yourself as you're figuring out how to approach folks for your teaching. They'll be asking, does this teacher understand my circumstances and objectives? It's nice if you are a lawyer or former practicing lawyer because you know exactly what the day is like. For example, if you're in a corporate law firm, you are billing by the 6-minute increment. And so somebody trying to sell you a 30-minute, meditation practice per day is really not going to go very far because it's not going to really fit into your life, particularly as a beginner. And time is literally money. Is this teacher someone from whom I can learn and want to learn, right? Are you somebody who exudes trust? It's something that lawyers have to do when you're trying to attract clients. And it's something they're going to be keeping an eye on as you're trying to say, okay, learn from me. Are you packaging yourself in a way that checks that question as well for them? And is mindfulness a proven and accepted skill? If it's a lawyer in a major law firm, chances are they've been exposed to mindfulness, but medium-sized, small-sized firms, possibly not. To overcome those legitimacy hurdles, just send them a law review article like Riskin's, or the fact that, or an email confirming the fact that continuing legal education credits are available for those who decide to take a class in mindfulness. Since lawyers have to have a certain amount of credits every year, kind of like mental health professionals or other types of professionals, they can check 2 boxes, take a class in mindfulness and have it count towards that annual requirement. Packaging and resourcing issues. Figure out what your benefit is. Are you selling a professional, organizational, economic, or wellness benefit? You can be talking to one audience and want to talk about why teaching them mindfulness will help their pro bono clients who survived a trauma in Africa and are now applying for asylum in the United States, would be of benefit before those clients testify before an immigration judge. You might want to be talking to another audience about how their law firm's employees will experience benefits that will reduce attrition and enhance teamwork. You could be talking to the lawyers themselves and say, okay, here is a way of managing your mind that will make you better at what you do, and will allow you to see outside the box solutions that might not otherwise be apparent. So just be clear about who's paying the check, and if it's different, who's your student audience and what they're going to need from your product, right? Professional issues, we talked about CLE credit. So one other thing to keep an eye on is make sure that, if they're showing a bit of skittishness around crystals and woo-woo, explain to them, no, there's going to be a PowerPoint slide deck. You'll see me in a suit. And what we're doing is addressing basic human needs that really are very, practical and secular and differentiated from any attempt to impart religious teaching. So for those who aren't yet familiar with meditation, I think those questions on the left are the right questions for you to answer for yourself, whatever your particular interest is as becoming a teacher to one of these student segments. So the right-hand side, again, the questions to run through, the checklist to run through before you approach a potential client, and it'll allow you to get clarity around how you shape your offering, deliver your offering, and show value from your offering. All right, next slide. To wrap up, here's some other resources in case you want to do a deeper dive on content. Charles Halpern began the application of mindfulness to the profession of the law as early as 20 years ago. So he's considered the elder statesman of mindfulness in the law. And if you Google his name, a bunch of useful resources and articles will come up. Same with Leonard Riskin. He had the seminal law review article in this space. My friend who runs Columbia Law School's program and my friend who runs Yale Law School's program both passed out his law review article on the first day as a way of legitimating the exercise in their schools. Daniel Goleman, you're familiar with his emotional IQ stuff. That's useful information to hand to a human resources director, for example. And he talks about mindfulness and its impact on empathy and team dynamics. Rhonda McGee and Richard Rubin are very, very well-known advocates of making mindfulness central to the legal education experience for all students. And she has a new book out that just came out last month, actually. So she and John Kabat-Zinn and Sharon Salzberg team up an awful lot to start getting mindfulness into various pockets of the law, particularly legal education. Really interesting to check her out. Angela Harris on personal values and professional ethics and how mindfulness permits individual practitioners to blend the two in their day-to-day practice. David Slotnick on how mindfulness can enhance trial advocacy, not just for your witnesses who might be nervous, but how you handle a jury. Really fascinating stuff at the confluence of law and psychology. And Jonathan Faust, I mentioned, just for folks who might be having massive backache tension, some great meditation exercises for lawyers who are sitting at their desks all day. So these are all folks who've done a lot of deep, rich thinking in the area, bigger names than any individual one of us just starting out, and useful to invoke as you're having conversations about bringing classes to various people in various formats. So if you have any questions, I'll leave you a couple minutes right now and then turn it over to Chrissy, and anything that we can't handle right now, just shoot me an email. My website takes emails, and you can reach me through the platform also. Thank you so much.
So Rebekka, how many more minutes do we have of you? Because you said you had to get out of here at 30 minutes, 6:30.
Yeah, let's 5 minutes, and I'll answer them very briefly, and then any overflow. I want to protect Chrissy's time, so I can handle all offline.
Okay, so does anyone, there was a lot of information shared. Thank you so much, Rebekka. Do does anyone have any questions for her right now? And another thing, if you can't think of anything now, you can go ahead and send questions afterwards as well, if Chrissy cannot answer them at the end of the session.
How many people are practicing or former lawyers?
Former.
Former? And where was your practice case?
In Oregon, where I'm from.
Private practice or?
I work for the public defender.
Ah. Yeah.
And I still I do teach some mindfulness in a prison in Maryland now.
To the guards or to the inmates or both?
To the inmates. Yeah, we're trying to get a guard program started, but right now just to the inmates.
Mm-hmm. Mm-hmm. And the legal profession, I should add, if we take an expansive view, includes law enforcement, right? So cops are starting to get into this as well, in part because they've seen how much good it can do in military settings. And the military has been, a very forceful advocate of mindfulness. Really, you want someone to, take a breath, take a beat before they shoot. And so in the military, when I was in the Pentagon, a very, very well-received program, completely repackaged for, Navy SEAL types so that it's not, unmacho, but the product sells itself, as they say, if you can get people to start.
Rebekka, I have a question for you. Are you okay with us sharing your PowerPoint slide on the website for people?
Yep, there's not a ton on it, but it's really intended to be, a tool for helping people ask the right questions, as opposed to giving out answers that would really be a one-size-fits-all. What I would say is that, if no one has any questions, what I'll wrap up with is just a modified one breath meditation that also will allow us to have a bit of empathy for folks who are in these high pressure professional settings. So I'll leave that to you, Heather and Isabel, whether you want to try that or not.
I'm totally fine with that. Yeah, and so just logistically, before you walk away, if you'd be willing to unshare your screen. Have you already done that? So Chrissy can, awesome. So let's do it. 1 minute, let's do it.
Okay, and so, this is one example of a micro practice that you can teach in a professional setting that will actually get people's attention, because they'll start seeing, oh, this is really not difficult to weave into my day, and there's not a huge opportunity cost to this, and hey, it actually works. So this is taken from the Search Inside Yourself program at Google, modified a little bit. But what I like to tell lawyers is, hey, you have a 6-minute increment, 0.1 hour, and this is just 1 minute of that. You don't even have to stop billing to do this meditation practice, and let's see what this does for you, okay? So, and we're going to pretend we're lawyers, so if you could just get in a comfortable position, and you can close your eyes or keep them open with a soft gaze, whatever you wish. Take a couple breaths. Imagining yourself in a really busy day. Unread emails. Your boss left a voicemail you haven't returned, and the phone is ringing, and your secretary just came in with something. In about 15 minutes, you have a client meeting, and you're going to meditate with the one breath meditation. Take another couple deep breaths. And keep breathing, and when you hear my cue, we're all going to breathe in a single breath. We're going to breathe in as much as you can, and at the top of the breath, you're going to hold it for 3, 2, 1, And then either on your own time or with me, we'll all let it out in a single whoosh. But before we do that, if you could just check in with yourself, given the day I described, what is the predominant emotion? Is it anger? Is it anxiety? Is it fear? Is it frustration? Just get a sense of what you might be feeling in this hectic day. Just name it. Okay, we're going to take this deep breath in 3, 2, 1. Breathing all the way in as much as you can. Hold it for 3, 2, 1. Let it out. Whoosh. Okay, keeping your eyes closed, breathing normally. Just sense if anything has shifted. And if it has, what is it indicating about the impermanence of anything negative? And in your own time, you can open your eyes and repeat as desired. And that's it. All right.
Okay, thank you so much. Bye. Have a great night, Rebekka.
You're in for a treat with Chrissy. Bye.
I know, she's wonderful.
Okay, can you hear me?
Yeah.
Okay. All right, so we're sort of shifting gears right now. Can everyone hear me? Because I'm in a conference room, so I don't want to shout, but I want, okay, great. And I'll leave time at the end for questions. And maybe if you think of questions, you can put them into the chat box. And if we run out of time, I don't need to go through everything. What I wanted this to be was useful to you. So if it's more useful to answer questions and to hear me just talking at you, please let Heather know through the chat box. So I will share my screen. All right. So I do have to give a disclaimer because I am a licensed attorney, that none of this is legal advice. And so this is just really what I hope to do, is to give you information about some of the things that you might need to think about when you actually are going in either to a law firm, a corporation, or wherever you're going to teach mindfulness. Okay, and so the first question I wanted to answer is, do I need a contract? And I guess the answer that I always give is, do you want to get paid? Because if things go south, you're always going to need something written, because oral promises are never going to stand up if you need any kind of legal recourse. So you definitely do need a contract. For a number of reasons too, because you need to figure out what is it that you're going to be providing, what are you going to be receiving in return, and all of the different terms that are going to govern the kind of relationship that you have. So who, what, where, and when. And also you could put the why, the purpose. Why are you entering into this agreement? That's always helpful so that people understand, okay, this is the kind of service that I'm going to be providing because you've asked me to provide it. So the who would just be the basic, you are the other party, and then let's say it's a law firm in this example, but it's not going to be any of the employees of the law firm or the corporation. The what is the type of services provided, the deliverables that are owed. So are you going to come in and do a live presentation? Are you going to be doing a webinar? Are you going to come in over time if this is not just a one-shot contract? And when are you going to be coming in to the company? Maybe you have a PDF or you have another kind of physical deliverable that you're going to be providing. What is that deliverable? And then on the other side would be, when is the company going to pay you? How are they going to pay you? So you would be putting in exactly, like if it's by check, if it's by PayPal, if it's by all of the pertinent details for payment, because that's one of the most important things. Sorry, I'm in a room and it doesn't sense that I'm here. If you can still see me, there we go. And then the format of your deliverables. So like I said, that would be if you have a physical product, if you're going to be doing webinars and things like that. And when, you always want to know, when is the date that this starts? So if you sign the contract today, is today the date that it starts? And what is the day that I need to provide my service? And when is this going to end? So a lot of times you don't need an end date because the contract is going to end when the services end. But sometimes you do, let's say in the example of milestones. So you're doing many programs you're going in every month and you want to set it for a year and then you want to renegotiate another contract. That would be one example. And termination is very important because you want to be able to get out, and just as much as the other party wants to be able to get out. So most companies will put in something that's unilateral and says that they have a right to terminate with written notice, maybe immediately or with 2 weeks notice or 30 days. You want the exact same ability to get out, because if it's not working for you, you want to be able to say, I'm out and there are no legal consequences, and you don't owe them any money or anything like that. There's some other terms in here. I just wanted to touch on them really briefly so that you were aware. I'm assuming, I prepared this as if you didn't have any knowledge of contracts, but if you're in the business world at all, if you purchase things, I'm sure you've seen all of these terms. So I'll just touch briefly on, so the intellectual property or the IP. If you're preparing anything written, you want to make sure that all the materials that you prepare are yours. If you don't want them to make copies, if you don't want them to put it up on their internal website or whatever it is, think of all the ways that your intellectual property, so the rights that you have in the materials that you create, think about how you want or don't want the company to be able to use that. Liability. Oh, and actually I should back up. So the other thing with IP, do you want the company to be able to use your name in advertising, either if it's, to different offices or however they might use it? You have a right to publicity, and it's different in every state, what your right to publicity is, but you have a right over using your own name and your likeness and your image. So that might become something that's important to you for various reasons. And then going ahead to liability, the two things that I usually look at are indemnification and insurance. So indemnification is if I do something and I'm trying to think of a good example here. If I do something and one of the employees of the law firm sues me, but it's because of the law firm's fault or their negligence, I want them to cover me. So if I get brought into this lawsuit, they're paying for me. So that's the basic concept of indemnity. And insurance goes to who's going to pay for that. So you might need to have your own insurance. You might want their insurance to be able to cover you coming in as a consultant. And these are just things that you might want to think about when you are going through a contract or talking to your own attorney, and figuring out what terms are going to be important for the type of work that you're doing. Governing law and venue is also important because let's say I'm here in California, but I'm giving a webinar and the person that is receiving it is in Minnesota, and there is some kind of legal issue. I want California law to govern because I'm here, and I want the venue to be here, the place to be here, so that if I get hauled into court, it's here and not over in Minnesota because I don't want to travel. That's something you sometimes have control over and you sometimes won't, but something to think about. And the disclaimers and no warranties I have up here is that it's similar to no guaranteed results. So if you're not a mental health professional and you're providing, and so I guess, and you are providing, if you're not a mental health professional and you are providing those services, you might want to rethink the way that you word the services. to the company or anything that can be taken like that. So a disclaimer would be, I am not a mental health professional, or I'm not a medical doctor, or whatever it is, and that you don't provide any guarantees as to an outcome or a result. And I'm sure people have questions about that, so I'll just go through. So I want to make, because I actually have a lot of things to cover. So how can I advertise my services? So the number one rule that if you're on social media, if you have paper advertising, if you have mail, if you have email advertising, is that you're telling the whole truth and nothing but the truth. It sounds very, very simple, but a lot of people get very tripped up over it, especially in the social media context. And then when we're getting excited about selling our services. So things to keep in mind are, whenever you're advertising yourself or your services, it has to be truthful and non-deceptive. And you're thinking about that just from the regular consumer, the regular client, the regular person who's going to come across what they read. Are they going to believe what you're saying? And is it actually true? So if you're also making any kind of claims like this will help you become happier, you need to have evidence for those claims. So you need to have something written to show actually people do become 10% happier, or whatever it is, when they take my courses, or you will feel more peaceful. If it's written as a factual statement and as a promise, you have to have evidence for those claims that you make. And unfair on the slide refers to, if you were just this average Joe that was reading one of the claims, would it be reasonable for them to believe that what you were saying is true? And if it's not, then it would be considered unfair. And so there are all kinds of different consequences for false advertising. I think the one that I wanted to point out the most is social media, because there are, in the beginning, when people were just advertising their businesses, or people were blogging about their businesses on, let's say, Instagram, there wasn't much of a crackdown, but people are taking these false advertising claims a lot more seriously. So it's something to be aware of. So testimonials, can I use testimonials? You can use testimonials, and the number one thing to remember is that you have written permission. So if somebody just comes up to you and says, you've led the greatest session, or they write it down on, if you have a sheet after that you circulate and distribute to people to write down their review of your sessions, you have to make sure that you obtain written permission and keep that as a record. And written permission would include things like consent from the person. I've agreed to give you this testimonial, and you may use it for advertising purposes, or you may use it to tell your other clients, or whatever specifically is you're planning to use it for. That's what, those are some of the things that you would include in the written permission. That also applies for social media. So if you were on Instagram, let's say again, and somebody writes a comment and says that you were the best thing since sliced bread, you need to ask them permission to repost that, or to use that in any of your other written advertising materials. And disclosing endorsements would be if you paid somebody to take one of your courses, or if somebody was getting something in exchange for any kind of review you gave, you would have to disclose that endorsement, which is perfectly fine to do endorsements. They just need to be disclosed. And then the last one was the any kind of advertising that you do would have to be relevant to the normal client and the typical experience of somebody who were to be taking one of your courses. So if there's somebody who's this great outlier and maybe it you know, quote unquote, cured their depression, using that would be not a great idea. So giveaways or promotions, there's actually no such thing as a giveaway. That's just the word that we use in the vernacular when we talk about giving things away, or we use it on social media. But there are contests, sweepstakes, and lotteries. And in a lot of places, a lottery is illegal. And in the United States, it's illegal unless you're the state or, you know, you're one of the authorized entities, but it most likely is not going to apply to any of us here. And it's sort of hard to sometimes figure out what's what. So I've broken it down here. So a contest would be something that someone enters and you're selecting the person. So let's say you were going to say you will win, 3 free mindfulness sessions with me if you submit a comment on my Facebook post. So the comment is the submission, and then you'll be selecting people. So that would be a contest. Or if somebody captions a mindful photo that you put up and you pick that caption as the winner, that would be something like a contest. A sweepstakes is winners are just selected at random. So there's no element of skill at all, and you're not doing any kind of judging of somebody's performance or their submission. And like I said, this is really tricky area. So you should definitely check with an attorney first, or get advice from a clinic, or at least do some due diligence around it before you just start doing them, because people do get into a lot of trouble. And I actually ran through that super quickly. So because I was worried we would run out of time. So I think it would be great if you had questions about Rebekka's presentation, because I also present in the law setting, or if you have questions about any of those topics that I brought up, or just any random topic about your legal contracts, if you have legal contracts, because I think we only have 7 minutes left.
Yeah, we do. We have 7 minutes left. As a reminder, use the chat feature, please, if you have a question. I have a few to start. So while people are getting warmed up, I'm going to go ahead and get started with those. So as I asked Rebekka, is it okay if we post the PowerPoint on the website?
Sure.
Yours. Okay, wonderful. And then could you direct us to a sample contract that includes all of these terms that you've outlined?
Okay. I could try to find one and post one.
That would be wonderful. Yeah, you helped with the website, so you could put it up there, or you could just send it to Isabel and me, and we'll take care of it. Yeah, whatever's easiest for you, Chrissy.
Sure.
And then what about common gotchas? You know what I mean? Like, have you experienced that at all? Like things people do that they shouldn't, or things that they should do that they're not doing?
In the contract itself, I think so. Sometimes people get surprised, like if there's an element of subjective, like the company has to like whatever the presentation or the product or the services or deliverables, but eliminating any kind of subjective element to that. So this is what I am providing, and I provide it, and you pay me.
How could you frame it? How would you frame a statement? Because I've done contracts too, and I know what you're saying. So I'm going to ask you to give an example of like what can happen when there's subjectivity there, and then how we could address that.
Yeah. So if you were, let's say you were to provide a presentation, and I guess it's when you are looking at the payment term, the payment should be based on the date of the service provided, and that the service has been provided, period. And you leave out anything else. If subjective words are like like best efforts, like that's not a legal standard. If you were ever going to use something like best efforts in any term, you would probably want to switch it to reasonable, because at least reasonable is a legal standard. So if it's not reasonable for you to deliver the presentation when they haven't provided, let's say they were supposed to set up this webinar for you, that excuses your performance. So that's actually another term that I didn't mention, is the excuse of your performance. Sometimes you see those in standard contracts like acts of God. So if there's a flood, I don't have to come in and do my presentation, but there could be other things that you can think about in your particular situation where you're not going to be able to perform your services, and you want to have that like get out of jail free sort of term.
Okay. So what if someone, I'm just trying to think, they try to get out of paying if they don't like what you've delivered. Do you know what I mean?
But I think that if there's no subjective element in there, they can't, because they've made an agreement that you deliver. And that's why a lot of times you have your contract and then you can have a statement of work and you can attach it to the contract, or it can be all part of the one document and you outline like in bullet points, this is what I'm going to provide. It's going to be a 20-minute presentation. It's going to be followed by, Q&A. It's going to be followed by a written summary or whatever it is that they're asking you to do or that you want to provide. And so have it very like a line item of these are what my deliverables are, and I'm being paid for the delivery of this at whatever date. And you can, 30 days from invoice, or at the date of the service, or if you have milestones after each milestone.
Mm-hmm. Okay, yeah. What I see a lot of vendors or people providing services, what they do, and what I think is very efficient and effective, is when they give a proposal, from the very beginning, they have the proposal with the scope of work outlined very specifically and the fee schedule, et cetera. And then they have the contract attached to it. So it's boom, boom, boom. You make it easy for that client to agree immediately, type of thing. So that's just something I wanted to share. And then what about scope creep? This might be more of a businessy thing, but I know that clients often will try to maybe get more out of you under the existing contract. And it's difficult with managing programs and so forth. So do you have any advice in that scenario?
Well, you can put in one sentence to take care of it, to say, other services not described in the statement of work can be provided under a separate written agreement to be agreed upon by the parties, so that it's clear that this is what I'm agreeing to do right now. And I'm not, if you want more, we're going to have to negotiate that separately. And you can add it in. So you can always amend a contract. If it comes up later and they ask you, well, I thought you also did X, you can amend your contract and add that in.
Okay, great. So I'm still not seeing any questions, but we have 1 minute left. So
I didn't go too fast.
No, you were great. I really appreciate it. So I'm going to ask that if people have questions, they can go ahead and email Isabel and me. We'll field them and get them answered for you. And then if Isabel's still awake, she's in Portugal right now. If she can just share a little bit about what's happening next month. So I'm going to unmute. Okay, there we go.
Am I on? I am on.
You're on.
Thank you so much, Chrissy. That was awesome. So helpful. You answered questions I didn't even know I had. So that was really helpful. And yes, so for December, so as you all know, we've been doing these monthly, or trying anyway. But yeah, we've been mostly successful at running them every month, aside from our break for summer. So for December, we're also going to take a break. And, they always fall around the 25th, so it was going to be a busy time for everyone. So we decided to put it on hold and then start again next year. But I will still be wanting to get some engagement from you, because I still want to, I was talking to Heather, and we want to kind of realign the focus of the group, because right now we've had a lot of people we have a bit of a core group right now, and most of the people who are part of the core group have volunteered to do topics. So it feels like we've explored all the speakers that were volunteering, and now we want to see what else this group could become, and how to make it more helpful for us, even as we grow in our journey, as we're becoming mindfulness teachers, and we start to get, in depth in our practicums and more out in the world training people. So I'll be sending out a poll at some point over the next couple of weeks for you to participate and give us your feedback and your ideas and thoughts of how we can make the best of this time and this forum that we've created. That is so great. We have people here with so much knowledge from all different areas. So I think it's a really great resource. So think about the kind of stuff that you think this would be helpful to do. So yes, so I'll be sending that out in the next couple of weeks, and then that means December we won't see each other, but we will see each other in January in whatever formats that may be. And we'll keep you updated on email, because that's really the best way to keep everyone on track. I think that's it, Heather. Is there did I miss anything?
No, just to add that I'll also be following up this call with an email with the video recording and any supplementary materials that are on the website.
Yes. Oh, and also I added something on the website this morning on the resource. So I found out there's this Mindful Workplace Alliance, and apparently it's a brand new thing. And they have, I don't even know who runs it, because there was 0 names attached to it on their about page, but they're on their resources, they have a blueprint of how to start running a mindfulness program in a workplace. It actually has really cool framework and links, and it's very helpful. So I was like, oh, everyone's gonna love this. But instead of emailing it, I didn't want to lose the link, so I just uploaded it on the website and thought I'd tell everyone later. So I'm telling everyone now. It's under the resources part of our website, so check it out. It's really helpful.
I'll include that. I'll include that on the email too.
Okay, perfect. Thank you so much, Heather.
Yeah.
You're on the ball. Right. So I'm gonna go mute again. Thank you, everyone. Thanks, Heather, and thanks, Chrissy. And Rebekka's gone, but thanks anyway.
Yeah. All right. Thanks, everybody. We'll be in touch. Appreciate it. Bye.
Thanks for recording. Bye.
Bye.